Now, this is something that people feel in the corporate world, in the legal world, that it is for the big companies. Guys, let me tell you one thing, that this is even for small and medium enterprises who are getting into maybe buying some shares for a business, maybe buying a business, acquiring a business. And this is not jurisdictional specific that with today's video. It is in general. When I see people buy businesses, they sign contracts, sign papers without getting into a lot of details, which is a must. Even if you're a small time business trying to acquire a bigger business, these are some of the red flags that will help you navigate any transaction anywhere that you're acquiring a business at. And these are basic clauses. Welcome back to my channel. I am 𝐒𝐓𝐿. I'm a legal advisor, lawyer, barrister and solicitor running my own firm. So if you have any questions by the end of the video, put it in the comment section or get in touch with me and my team. First things first is your due diligence. Now, it can be very difficult to navigate the entire paperwork, whether you're checking the company's financial, you're checking their legal history, you're just checking the regulatory health of the company. Now, what happens is usually in a rush, you will see it's a good deal and let's sign the agreement. But guys, why is it even on the market? Why is it selling? Did you go into the details? Did you look at parallel books if they have? I mean, there is so much when you acquire a business anywhere that you need to go through. Your diligence is the first step, and if that is not done properly, you will end up actually in a legal trouble. And this is bad for me, but I still advise everybody to go through that due diligence process. Hire an expert, a professional who is able to tell you that what is the exact health of the company that you are going to acquire. Even if you're going to sell, what is the exact health of the buyer? Are you going to get the payment in tranches? I mean, there's so much when it comes to a share purchase agreement, asset purchase agreement, acquiring anything or merging with any of the running businesses. Vague or misrepresented warranties and not having the right indemnities in place. Now, these are terms that you might think are legal, but I'll tell you what exactly this is. Supposingly somebody has a vague term in a contract and tomorrow you go over dispute. Who is the judge going to favor it? You do not know. How the arbitration dispute resolution is gonna work, you do not know. So if there is a representative clause which is misrepresented, read it carefully, get it reworded. Otherwise, you are entering a blind deal. I always say that whatever warranties you are taking, for example, if you're saying you will be responsible for a particular thing and the seller is going to be responsible for a particular thing, always have indemnity, that in case anyone lapses, then you are indemnified, right? So that indemnification clause covering you from the risk of unknown should be there. And by the way, this is the big companies are having lots of corporate counsel support, all that is there. Still they can go wrong. So what you should do as one person company also, even if you're a sole owner of a company, you should actually vet the documents, sitting besides the professional, going through everything, understanding what you're going to enter into. That's very important. Now, you have signed the agreement, you have taken over the company, but you exactly don't know how the allocation of the liability is going to work. You close the deal on 21st June, let's say, hypothetical date. 22nd June, there is a claim. Who will take that responsibility? There is pending tax issues. Firstly, if you've done your due diligence, these issues won't arise. But still, if there are certain things that branch out at a later point of time, who is going to help you navigate that? Who is going to take responsibility? Who is going to have the allocation of liability? Now, this is something I always focus on. Is for my clients particularly, I'm very, very professional in terms of asking what is the foreseeability of this business, what is I can expect, because all this is like signing a ticking time bomb if it's not done properly, and at least if you don't know what you're signing up, right? So it's very important you allocate the liability before and you're ready for it if you're ready to accept it. Fourth thing is very important, again, as per all my pointers, is that if you are signing an agreement which is heavily one-sided. Now, why this happens? Sometimes in a deal you are doing a distressed deal. Maybe you're selling out of some kind of XYZ reasons, emergency reasons or anything. What happens is the other party gets into a dominant position. Now for everybody who is in a dominant position, it's also about negotiation. Remember, your side is not weak, it is just the timing, okay? So if you are selling something profitable, or if you are buying under a distress deal also for that matter, and you feel that you are trying to claw back the other person, it's not correct. Contractually, everything in the court will be looking at in good faith. This is like an overview. But of course, what you should be doing is ideally never sign an agreement which is one-sided. One-sided agreements are not fair deals. Good deals are actually fair deals. Okay? So if you are signing into something like that and you feel, this is like a lot of things are in favor of the other party, beforehand only clear it. Okay, the deal might not go through, but you will save a lot of legal hassle that you can enter into later on. And honestly, if this one step in which you try to be reasonable with the other party, even the buyer, even the seller, they try to be reasonable, then the contract should ideally never be one-sided. And fifth thing is, guys, never sign agreements that are not enforceable. Enforceability clause, I cannot less focus on it. What if you sign into a non-solicit or non-compete clause, but it's not enforceable by UAE laws or any jurisdiction that you plan the agreement to govern by? So if it is not, then what's the point, right? Always have covenants, especially restricted covenants, signed in the jurisdiction and clearly mentioning. So for example, if you want UAE courts to be applicable, write UAE courts to be applicable. Also, if you want DIFC arbitrator to be appointed before your agreement, have that in writing. Who is going to appoint the arbitrator? What is the arbitrator's power going to be? What is the seat going to be of arbitration? Or if arbitration is costly for you, just add a clause of mediation. I mean, some agreements, they don't even need arbitrators. Arbitrators is for big companies, right? So even a mediation and negotiation clause or dispute resolution clause before enforcing the real jurisdiction of the court can help you, because your contract is your governing body. So it's very important, everything you sign and anything that you sign in the agreement, you stick by it, you take it in good spirit, you enforce it, and it should be enforceable to the other party as well. I always say that if you want to add some kind of clause which is helping you, get the professional involved and let the professional do the negotiation for you. You don't have to face the other party always. Sometimes it's better to have your professionals run it with a legal lens and give you a proper review, even if you are entering into a contract or want an exit. And by the way, I have shared a free guidebook in the description box for mergers and acquisitions, even for SMEs and large companies, the rules that govern here in UAE. I hope it helps. And if you want more such legal tips, follow me on all my channels and subscribe to my YouTube channel. Thank you for watching today. Do like, share and subscribe to this video.